The federal government has taken the step to address property division on First Nation reserves. It's not law yet, but legislation has been passed to allow courts to interject in the case of a divorce or death. Local advocates say it's about time. A divorce is a trying time for anyone, but imagine if you could be kicked out of the marital home without any legal recourse. That was the reality on Canadian reserves until this year. The federal government has passed legislation to deal with matrimonial real property on reserves. It refers to the division of immovable assets like the family home.
The division of property on reserve comes under federal jurisdiction. And so the division of property on reserve was not really addressed by the courts in a meaningful way.
Bill S-2 was passed on June 19th of this year. It allows for the choice of federal law or community-specific law.
I think you see more cases stepping forward for First Nations women to wanting to exert that right, absolutely.
The former law dates back to the Indian Act, which has no provisions for divorce. In a landmark case, Derrickson versus Derrickson, the court ruled that neither provincial nor territorial law could be enacted because it was federal jurisdiction. Most likely, the house would end up with the husband, especially if the woman was from another band.
Oftentimes, the women were just forced to leave through decisions of the husband, the estranged husband, whose home that the home would have been registered to, and then also the bands. So the bands also played a part in saying, well, she's not actually our band member.
Local advocates say this has a direct correlation with poverty in women and children in this country.
The way it's set up there is that a divorce or the children are involved there. Absolutely, the First Nations women aren't recognized, and basically that would be one of the factors of poverty for sure.
There will be a 12-month transition period once the legislation becomes law. There's no date set for that yet.